Do I have to send my child to visitation with the other parent? Can the other parent keep our child away from me because of COVID concerns? Let us take a look at those questions and others. I'm Michael Miller, a partner at Cole Miller, PLLC, located in Vienna, Virginia. We are a family law firm serving primarily in the Northern Virginia area. I analyze challenges and find affordable solutions for families as they address their legal needs. In our previous video, we reviewed the state of the courts and their ability to hear motions and trials. Now, life could have been very simple had Executive Order 55 from the governor, dated March 30th, been written differently. It could have explicitly prohibited travel for custody matters. However, it was not. It says in paragraph 1 that all individuals remain in their places of residence, except as provided in Executive Order number 53. It then continues that individuals may leave their residences for purposes of traveling required by court order to facilitate child custody, visitation, or child care. So, no cover in Executive Order 55 for the parent who wants to keep a child away from the other parent. There's a widely stated proposition that it takes an order to change an order. If a past order provides for specified parenting time, the proper way to change that is with a new order. The proper course of action is to seek a new court order to address the current circumstances. The problem here is that courts were not offering hearings for the past month or so, and they are now maybe offering a mix of in-person or remote hearings. But there may be more urgent matters on the court's docket to address over a custody modification. So there are certainly parents who have the literal versus the statutory definition best interest of their child at heart. I'm sure there are many parents who are able to agree to suspend in-person parenting time or to substitute web access. They may have agreed to consolidate parenting time in the summer with the other parent having an extra week or so of summer to make up for missed meals. So this is a way that the parents can cooperate with each other. But there are also no doubt parents who have used and will use the COVID pandemic just to aggravate and retaliate against the other parent. The primary custodian may want to keep a child regardless, and COVID provides a convenient excuse to withhold access. Likewise, a parent who might honestly find that there is a risk associated with exercising parenting time due to at-risk persons such as grandparents in the household, but they'll still insist upon adherence to the schedule. Now, not only is the parent who wishes to modify the schedule hampered by the lack of access to the courts, but the parent who wants to enforce access is similarly limited. Rules to show cause and motions for contempt will be difficult to get on the court's docket and get heard. Now, the judges will find a challenge when they hear these rules to show cause as to whether they look at that in the present time. Maybe looking back, a parent's position is unreasonable, but what about at the time the decision was made? Did the parent act in defiance of the court's authority or as an insult to the court's dignity? And what would be the remedy? There's only so many weekends. Make-up time may not be feasible. During the pandemic, with everyone at home, parenting time is abundant if one can get one's child. But providing a week of make-up time when the children are in school and the parents are back to work does not provide the same quality of parenting time together. Then to add the next level of complexity, there could be criminal violations. Virginia Code 18.2, 49.1, a violation of court order regarding custody and visitation penalty. Paragraph A. Any person who knowingly, wrongfully, and intentionally withholds a child from either of the child's parents or other legal guardian in a clear and significant violation of a court order respecting the custody or visitation of such child, provided such child is withheld outside the Commonwealth, is guilty of a Class 6 felony. Paragraph B. Any person who knowingly, wrongfully, and intentionally engages in conduct that constitutes a clear and significant violation of a court order respecting the custody and visitation of a child is guilty of a Class 3 misdemeanor upon conviction of the first offense. Any person who commits a second violation of this section within 12 months of the first conviction is guilty of a Class 2 misdemeanor, and any person who commits a third violation occurring within 24 months of the first conviction is guilty of a Class 1 misdemeanor. So far, we have only examined the parents. We need to also consider the children. The best interest of the child factors are at Virginia Code 20-124.3. Now, the children's lives have changed substantially. The children are out of school, they're away from their friends, they're out of their extracurricular activities. It might be something as parents to consider providing additional parenting time, such as video teleconferencing, even if it's not provided in the custody order. One could not only stay on the ordered schedule, but they could also provide some additional time. Likewise, the parent getting parenting time needs to reflect on their circumstances. There may be no question that the court order provides your time. However, there could be a valid concern about the child's welfare. As mentioned above, are there grandparents or other family members in the household who might be at greater risk? Is one parent or the other in higher risk employment with risk of greater exposure to COVID? Now, a couple things to keep in mind if there is eventually a hearing and that the best interest of the child factors apply. Factor 3 says in part, the ability to accurately assess and meet the emotional, intellectual, and physical needs of the child. Factor 6 says the propensity of each parent to actively support the child's contact and relationship with the other parent, including whether a parent has unreasonably denied the other parent access to or visitation with the child. Factor 7 looks at the relative willingness and the demonstrated ability of each parent to maintain a close and continuing relationship with the child, and the ability of each parent to cooperate in and resolve disputes regarding matters affecting the child. Some aspects of family law can be fairly objective and quantifiable. If you want to know the value of a savings account, you look at the statement. Other matters are almost entirely subjective. Reasonable minds can differ even to the point of reaching opposite outcomes. There is no question that one day you can submit your dispute to a judge. The judge will diligently listen to each side and will announce a decision. You may or may not like the decision, but you will live with it. However, what I have found is that parents frequently get a better outcome by deciding for themselves as the persons who are best informed of their circumstances. With the COVID pandemic, more attorneys, mediators, counselors than ever before are available to you via remote conferencing. Your child may benefit from you and the other parent making that effort to seek an agreed resolution. That way, then, a new agreement can then be submitted to the court as an amendment to or replacement of the existing custody order, and then you can proceed.